But I looked at the statute, and I think Heather's office didn't see the problem either.
Well, I got back to
Just his judgment.
Yeah, I know, maybe he'll bring treats.
I was thinking of being, I got home, looking at my calendar, and I said, oh my God, I got about 3.5 hours.
You know, when the leaves turn, I think, it's so pretty in Iowa, I couldn't live anywhere else. And then winter comes.
Just in my car.
What am I doing here?
I drove from
So,
near Las Vegas to here yesterday. So going across all that sand, you know, the desert and all, and it looks like a wreck.
Did you come from San Diego then, all over here? The one called, you're from San Diego? You started in San Diego?
Well, from San Diego, I went to near Las Vegas,
Okay.
and I got to get back up now. Where did I stop?
These are orders and things that we
You go across
anticipate
Utah
being
and,
to be signed.
to
So
Grand Junction and
just
that
done it
area.
that way so that I
Oh,
won't
wow,
overlook
well.
it.
well,
I'm trying to remember where the
I'm
second.
feeling out of sync. Maybe I'll put my mask on.
I guess I
Zach,
didn't
you
have-
want to grab that door? Just,
So I stopped east of Las Vegas,
we're gonna get
You're gonna have a
too much
noise.
walking.
then from there.
Oh,
This town is now called Hurricane.
Oh, yeah, I heard that. Yeah.
Let's go ahead and pass on.
I've done that with my daughter a couple times, taking her to LA.
Eastern Nevada.
So then, Brett, I take it from the tone of the last text that she's not calling
I
in?
like you
I'm
all.
guessing not.
Okay.
The one thing that's feeling.
You know about that?
Yes, that's right.
Bill Nagy.
Yeah, because I talked with him originally.
You have to watch your gas tank.
I know Margaret's name is on it, but I can always go over that.
Do you need any of these files?
The ones I have marked that I worked on, Heather, Kiteworth, and Weinbrenner. I think we can just wait until we get to them. And then if there are any others that you want me to go over, just throw them my way. And I looked over all the orders, so I'll be able to
Yeah,
fill in.
well, I'm probably gonna defer, if we can defer to you. if
Flags
you want.
on my.
Yeah.
I use them. That's
If you can go through those first several things that you were gonna do anyway.
Yeah.
Okay. And everybody's got a copy of that, those Supreme Court orders in their
Yeah,
packet.
that was a good idea. They're kind of big, but
Actually, I had someone contact me about the Ripperger kind of issue earlier today. They thought it was an ethics violation to not have their address listed on the assessor's website.
what?
Yeah, it's someone who's running for Woodbury County
Here's
Attorney.
one of your easier questions.
Yeah,
Someone from Woodbury County?
I think
Stopped in.
my auditor said that she was running for county attorney,
County attorney, oh, yeah,
Jacqueline
oh, yeah.
something.
Jacqueline Fox,
Came
yep.
back
Yes.
up.
Do you know her?
I'm working on, I think I'm chairman of her campaign.
Oh, okay.
I don't know what happened.
I'll try.
Hey, so we have a conflict there. All right, stop.
You got too many hats on.
I've known her father for 40 years, and so she
Okay.
said to run for county attorney, and it was, so,
You want to pass that, Keith?
and it
That
was either
clipboard?
treasurer or the chair, and I thought, I'm not gonna be treasurer. I
Yeah.
don't know how to be treasurer, I don't want to be treasurer.
Is there any
Well, it just
different
confirms
here?
what I've always said, that you're no more than 1 or 2 degrees
Not,
removed from someone
except for the
not.
Hoffman one was sent separately.
Just, she didn't know if that it was unethical for an elected official to
And it's
have their
just a motion
address
to
removed from
continue.
the
I saw it
assessor's
online,
website.
so I didn't copy it.
That's the only one.
I don't know,
It's unethical?
she thought it might be a violation, I just said,
Okay.
no, it's
I
not.
mean, I thought that was part of the Back to Blueville.
Well, and that was the context of it,
Okay.
was she thought that it might be, and it's not, it was always
For a
available.
local official to.
Yes,
Okay,
yeah.
okay.
You're supposed to know that stuff.
I'm still
Well,
learning on the job.
I mean, I have two
But you
judges
knew
who
the
live down
answer to
street
that
from
one.
me, and I was wondering if they had been victims of title fraud because they're just totally different names.
Oh, really?
I can the property in Beacon for them,
Interesting.
and just totally different names. But, you know, the judges are still living there, because I see them coming in and out of their house. So I don't think it can't be unethical. It's exactly what people do.
No, no.
Oh, yeah.
Plus, I mean, with how, both between the Ripperger decision and then also, it was just, you know, I know Megan Tooker had her address removed, I got mine removed.
Yeah,
Because I
yeah.
knew I'd be in public service, so, you know.
Well, I had several coworkers at American that their address removed because their husband lived there. So
Right. And I think the only thing that the Back to Blue bill changed was it no longer was just kind of an informal request. It was you shall do this if it's a prosecutor or a police officer.
They wouldn't let me change it.
Do you know if you have
That's interesting. I guess I'm still in my Polk County bubble.
I guess we're ready to start. Do you want to call the roll?
Okay, Joan Corbin, are you on the phone?
Present.
EJ Giovanetti.
The president.
Barry Lindahl, are you on the phone?
Here.
Keith Luchtel.
Here.
Monica McHugh, are you on the phone?
Here.
Rick Moraine.
Here.
Julie Podorf.
Here.
Susan Stewart.
Here,
Stan Thompson. Margaret Johnson, are you on the phone? Julie, you have 8 present and 1 absent officially.
Who else do we have on the phone for the meeting?
Barry Lindahl.
No,
I'm sorry.
other than board members. Gotcha, Barry.
Amy Beatty on behalf of the City of Mitchellville.
Susan Patterson-Plank, Iowa Newspaper Association.
Laura Burgess on behalf of the Amana Colonies Land Use District.
And your name again
Becky Elp, file a complaint.
on the Amana one?
Laura Bergen.
Yes.
Thank you. Anyone else on the phone for the meeting?
Tammy Phillips. Aaron Mullinex with
I gotta find a better way.
Say it again, please.
Tammy Phillips for the City of Mitchellville.
Joe Mosier from the Finley Law Firm.
And are you here for a case?
Aaron Mullinex with the Iowa League of Cities.
Steve Brick for the City of Waukee.
Anyone else? Okay. Can I have a motion to approve the agenda?
Move.
Second.
Moved by EJ, seconded by Rick. All in favor, signify by saying aye.
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 Aye. Aye.
The agenda is approved. Approval of the December 16th minutes. Do we have a motion?
So moved. Second.
Moved by Keith, seconded by EJ. All in favor signify by saying aye.
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 Aye. Aye.
Minutes are approved. Do we have anybody who wants to use public forum time? Guess it's going to be once in a blue moon when we get a public forum speaker. Comments from the chair. We have 2 Supreme Court decisions, and I thought when I asked to have them put on the agenda, we'd have final decisions. But as it turns out, neither of them are actually final. Somebody is right up by their microphone. It's making a noise. Both of them are being remanded. Ripperger is going to be remanded to this body. We don't have a remand order yet to decide the question of what outside government means. As you probably recall, the case was resolved and we found that 22-718, which allows for keeping communications from persons outside of government confidential, if the government body could reasonably believe they would not communicate if it were going to be public record. That's a paraphrase. Court disagreed. Thought it was reasonable to think people would rather be searchable on the index than be identified as having asked that their name be pulled. So we never crossed the threshold of who outside government people are who would qualify for that confidentiality. It'll be remanded and set for contested case probably before an ALJ and then come to this board on appeal. So we probably should defer further discussion of Klein since we'll be seeing it again to answer that one legal question. The second case, the Ripperger case, is also being remanded, but not to us. The court found that Mr. Klein had standing. On remand, the court had thrown it out for lack of standing and failure to exhaust remedies since he wasn't there for the contested case. The court is allowing him to proceed with a challenge to a very small set of records. The dash cam footage, which apparently didn't get resolved in our contested case, and there was some unclarity about whether there are other 911 tapes that weren't disclosed. Those are the only matters being remanded to the district court for resolution. The court is not going to let him litigate things that were already disclosed by the federal court. So I don't think we're going to get a court decision on whether body cam footage or 911 tapes are indeed part of the investigative file or not. The board held that they were, and then they were disclosed by the federal court in the course of civil litigation. So it will go back to the district court for the judge to address and tell me if you disagree. Only the question of the dash cam footage that kind of got, I guess, lost in the shuffle, and any other 911 tapes that hadn't already been disclosed. It's unlikely that it will come back to us again. Hopefully the case will be finally decided in the district court. Since both cases are still live and being remanded, I think we probably ought to limit discussion about the merits.
We won't have anyone talk.
Pardon me?
We have Emily in the room.
Emily, you don't always recognize people in masks. Hi. Hi, Emily. We were just briefly going over the two Supreme Court decisions.
Okay, yeah, sorry I'm late.
That's all right. And I was suggesting that we probably limit discussion anyway, because both are being remanded, although to different places.
Right.
Ripperger, we don't seem to have a remand order yet for litigation of the question of who is outside of government for purposes of 22-718. But that should come soon, and I imagine we'll set it for a contested case hearing before an ALJ.
Yeah, and that one, just so you're all aware, Megan Gavin from the Polk County Attorney's Office, who was representing their assessor, reached out to me, I don't know, maybe a couple weeks ago and just said, I guess asking if there was any possibility of resolving the case. She thought it might be one where there was a good potential for resolution, and I said that would be up to the board ultimately, and I forwarded an email along to Margaret, so.
Well, we'll cross that bridge when we
Just had, yeah,
see what she has.
wanted you all to be aware that I
Okay.
did not know, but.
And then I had mentioned also that the Klein case is being remanded back to the district court judge for very limited determination of the dash cam footage. And I remember you mentioning that to me at one point, that had kind of been left in limbo. We didn't really address dash cam footage. That can be addressed, and if there's a 911 tape that wasn't already disclosed in the civil federal court proceedings before, I think, of Gritsnack.
Right.
And
But
that's,
yeah, and I have not seen remand orders in either of those cases. The cases got issued towards the end of the year, and then in Polk County, the judges rotate at the end of the calendar year, so.
oh, it'll be a
The
new,
judges have rotated off, I think. I'd have to check that. So I might need to just jog them at some point, just file something to say, hey, are you going to remand this to the board? But just in case it got lost in that shuffle.
shuffle. Okay. I guess one moral of all this is that litigation is not speedy.
True.
I thought they'd both be done by now, but they're not. Unless you have something to add, Emily, I think we'll move on to advisory opinion.
Yeah, no, unless you have a question or anything else you want to discuss, Julie.
No, I think we're best limiting our discussion since both cases are still live. Advisory opinion. Do you want to handle this, Zach?
Did you make an answer to the Margaret's not here?
Oh, yeah, Margaret slipped and fell, had a back injury and wasn't able to be with us. She has trouble sitting for very long. So we've got a special return appearance by Zach to help us out at this board meeting.
Makes me feel like I'm a TV guest star or something.
Yeah, hey, yeah.
All right. So this is Advisory Opinion 21AO0009, prepared by Margaret Johnson. The factual background in this case was a city received a request for records, and the city's legal counsel then posed us the questions. One, are the records on private devices that are being used to conduct the work of public officials, public records? And then the second question is, to what extent does the city have to make an effort to go on to people's private devices in order to retrieve the public records? The attorney cited some informal guidance that was given back in early 2020 and is available on our website, and that is reiterated in the opinion under question 1. And the gist of it is basically that the content of the message is what determines whether it is a public record or if it isn't a public record. It does not lose its status by being retained on a privately owned electronic device. And Margaret cites a Supreme Court decision from 1967. While it is before the time of email and personal cell phones, it nonetheless still has some relevance. And to quote from that case, they say, "It is the nature and purpose of the document and not the place where it is kept which determines its status." So whether it be on a personal cell phone or a publicly owned computer, it is the content of the message. And to allow a governmental body to avoid public records disclosure just by keeping it on a personal device would obviously go against the goals of Chapter 22. The second question is a bit more complicated. The second question is that if such records were subject to an open records request, who must review the devices, the personal devices, to determine whether the emails, text messages, and other records are responsive to the request? Margaret goes in and advises that commingling any kind of public communications or reports with private communications are going to result in some difficult situations. She also cites that Iowa Code Chapter 22 does not provide specific guidance on how a lawful custodian must retrieve, review, or release public records, and that it would be appropriate for a government body to develop a policy governing the use of private devices for government business. The policy could require that the lawful custodian have access to private devices and the mechanics of such access, including any privacy concerns that the owner of the personal device might have. She goes on to state that any government officials and employees should be advised that failure to cooperate with the release of public records pursuant to Chapter 22 could make them liable for civil enforcement proceedings under 22.10. The IPIB has also recommended that a government could require the use of specific government email address anytime a government official or employee uses a private device to conduct government business. I know that's how I currently do it with my personal laptop. Everything is through the iowa.gov email account, so nothing is stored on the actual personal device. So any entity that meets the definition of a government body under 22.1 sub 1 still needs to comply with Chapter 22. Using a personal device does not circumvent those requirements, and the lawful custodian of those records needs to ultimately will have the responsibility to ensure that the public records request has been fulfilled pursuant to Chapter 22. If there are any questions, I'd be happy to try to answer them.
Is there any Iowa case law? I remember when I, a few years ago, looking at, or was developing case law on the ability of an employer to look at your personal devices. Is there any Iowa case law on that?
Not that I could see, and I had Mr. Zeschke, I talked with him initially before Margaret took over the advisory opinion, and that was his main concern as well, was is he going to have to go into a city councilman and say, give me your phone so I can look through your text messages. He couldn't find any relevant case law on that, and even then I don't know how it could potentially supersede Chapter 22 and the requirements there. So I guess the short
I mean, I
answer
still
is
think
I'm not
turning
aware.
over your personal devices. No one has, certainly, Chapter 22 was not adopted when there were such things.
Right.
Other than maybe letters in your house.
Yeah, and I think that's why the best course of action, and what we've seen, we have a case that's ongoing right now with Iowa Workforce Development. There was a
Yeah.
request for text messages on the director's cell
Oh,
phone.
yeah, yeah.
That cell phone is owned by the state, so it's a little different. But at the same time, we're working with, or the IPIB, not me anymore. They're working with them to develop a policy, and I think that's why Margaret mentioned what she did. I think the best course of action, absent of any kind of controlling case law and the fact that there just isn't precedent for this kind of technology, is to have policies in place to prevent any kind of issue from arising in the future.
I mean, I recall a decision, it was in a totally different setting, probably 5 years ago. A bunch of employees were, communicating on their personal computers with their personal email addresses about things related to their workplace.
Right.
And I don't remember how that case came out, but that's the kind of thing that
Yeah. I will say the only
present issues.
Yeah, I will say the only thing that I'm aware of in that context was a certain agency, the Ethics Board, of course, coincidentally. There was the issue a few years ago of using personal email addresses and whether or not to make those available to members of the public. And I know that this board ultimately decided that that information, since it was being used by the Ethics Board members to conduct official business, those email addresses were public.
I think in that case, they came to the conclusion and agreed to turn it over before we.
Yeah, that's correct. I know Megan complied,
I appreciate
and we're
that.
still in compliance today, so, yeah.
This is Barry. Let me ask you this. Who would be the custodian of a public record on a council person's private device? I mean, who's the custodian?
Well, I think it's still the government body that's concerned in the communication. I know in our office, we've sent people to, it was EPC, the Environmental Protection Council. They don't have official computers, they use their own. And when you got a public records request, we just sent an attorney over to the house to look for what were public records. People were very cooperative.
Yeah. And I would just add that I think, again, with these more novel issues of how technology has developed, such as with that Iowa Workforce Development case, they tried to say that, the text messages requested, you go to Verizon for it. So I think there could be a lot of different arguments as to who's the custodian for what. Is it the person who has the actual cell phone? Is it the provider who is responsible for delivering the information sent from the phone? I think that is a very
There's all sorts of
unresolved
issues,
issue, just because everything is so out there technology-wise these days.
I guess I would ask Barry, as a city attorney, is there, in your personnel manual, is there typically anything that says you may have to turn everything you have over to the government body in the event of a public records request?
Yes, we do advise them of that, and when there are requests, we handle it different ways. I mean, you can either just ask them to tell you if they have any public records on their personal devices, or we can actually, we can track down. Well, if it's on a personal device, we don't have any record of that, so I don't recall that we've ever asked them to turn over their devices. They have somebody in our office search. We just, I believe, have just asked them to tell us whether they have any public records on their personal devices.
Yeah.
The one thing, I guess, we had a case long ago, Pete, that got settled, and it was a teacher communicating with a parent about a student. And all these teachers, I think, communicate on their personal devices with parents. And obviously, a lot of that would be FERPA protected, but, there's an awful lot of employees out there that probably have no idea someone could come knocking on their computer or their phone someday.
If I remember correctly, that one, the issue was with the school district, and they claimed, well, it's not a public record because it's.
Okay, yeah, I don't remember, I just remember it involved, I think, the most granular kind of flavor of this issue.
Right.
This teacher with a personal cell phone.
Yeah. And I will note, kind of similar to what Barry described there of, asking the city officials for the records. In this factual pattern that Mr. Zeschke described when he first called me, they don't know for sure if the records, he just got one of those all-encompassing record requests and just wanted to make sure that he was compliant. So there's no indication that the city council members or what other officials who would be subject to the request are refusing. He just wanted more guidance on how he should go about doing that to respond to the request.
But to Susan's point about who's the lawful custodian, I don't think that changes. The lawful custodian is still whoever's designated for the government body
Yeah.
in charge of public records, and if it's on your
They have to
personal
gather-
device.
Yeah, they have to gather the
Right.
devices. I guess my question still is, will the law require them to turn it over?
Well, I think the key would just be, if I were that city attorney, I would make sure that they are aware that you will be liable for civil enforcement under 2210 if you don't comply with this request. And that would hopefully be all the encouragement they need to not use their
I think it's
private
a
devices.
question whether, if that ever went to court, that provision would stand up, but that's just me thinking about other things.
Any other questions or comments about the advisory opinion?
Yeah, we do, in Dubuque, our policy actually says the city clerk is the custodian of public records of city council members, but we certainly don't want to put her to the trouble of doing those kinds of searches, so we typically end up doing it ourselves, so.
There are no other comments. Do we have a motion on the advisory opinion?
Moved.
This is Barry. I would move to accept the advisory opinion or approve it.
Okay, we had a motion by EJ, so we'll have a second by Barry. All in favor?
Okay.
All in favor of approving the advisory opinion signify by saying aye.
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 Aye. Aye.
Any opposed?
Aye.
Any opposed? No. The advisory opinion is approved. I think on the next item, the practice has sort of been to have rules come up through the Rules Committee, but I kind of wanted to flip it and get any thoughts the board had, and then the Rules Committee can work on what assignments we have from there. And as luck would have it, we had a memo from Zach, and here he is back with us. So I think that's a good beginning point if we want to go through Zach's suggestions and get some feedback, and then the Rules Committee will take it from there.
Yeah, so this memo, it's admittedly rather skimpy, just over half a page. And basically what it is it's a compilation of things that I think have been floated out there either during board meetings or in discussions between committee members or even just those of us in the office back when we were all in the office. And so the four ideas that we had, I know that we had some issue. It was originally proposed. I don't recall under which matter, but that's beside the point. One of the probable cause reports I did recently wanted to use this rule, which was implemented by Charlie Smithson, and he implemented it because during his time as executive director of the ethics board, they had an identical rule. So when he was director of IPIB, he implemented it. We're just all entwined. There's no way getting around our two agencies being tied at the hip. So anyway, that's the little bit of the background. He put that rule in place when he was executive director a few years ago that would allow the board to order administrative resolution at any point through the complaint process. And I know when I put that recommendation in my report, Julie had voiced some concerns about that running afoul of 17A.
And I think the rule even purports to call it a final decision under 17A, which it can't be because you have to have findings of fact, conclusions of law under Chapter 17A for a final decision.
I did talk to Charlie. My memory isn't as good as it could be about this because I think I was the chair when this got adopted. But if Keith will recall that, at the beginning, there was a real concern that things were going to move way too slowly. And, from Bill Monroe, who was our chair then, and he was really concerned about that. And I think that was Charlie's attempt to try to deal with, things that were obviously wrong or right more quickly than possible. Now, I don't know how it's been used at ethics, if it's ever been used at ethics. And if we're just basically assuming everyone knows it's going to take at least 60 days to get anything resolved here. But I think that was the genesis of that rule, and I don't know how it's ever been used at ethics, if at all.
Yeah, and I know I should probably be more aware of how it's been used in the
Okay.
past, but I'm not aware of
I
exactly
think
how frequently
His
it's been
contention
used.
was whatever that order was would be a final act, would be a final order, and I thought one of the court cases kind of came close to saying the same thing. I mean, not about this rule specifically, but about any actions our body takes.
Well, what the last action you take would, I guess, be the last action, but it doesn't meet the definition of a final order. And I think Zach raises a point, we could kind of modify it and save it for, as a follow-up order, but I think it'll still cause confusion if it's out there. And then people will be tempted to. The one thing it would be was fast. Order people to disclose and do away with fact-finding and conclusions, so.
And I think, we've been in existence for 10 years, and I think maybe everyone understands, we have enough of a process. Everyone knows it's not going to be fast, that it's probably going to take at least 60 days to get any kind of resolution if you file something with the board. So maybe we're living in a different world right now.
Well, ironic to take up the issue of speed on the heels of these two Supreme Court cases that are years in the making and they're still not done. I guess I'd like to see us just repeal it and not try to
Just
save
what?
it. Repeal it and not try to save it.
I don't have strong feelings one way or the other. I think the idea that you could get resolution in 10 days that I think, Bill Monroe was looking at real quick stuff. That's just not, anytime you send anything to government agency, that's not going to happen. And our agency may be better than others because we answer the phone and we give you, if you're doing something right, we'll tell you that. And perhaps we forestall any complaints.
I wasn't sure what you were saying, Julie. I don't know what the math has to do with it. Nothing, but I have a hard time hearing.
What I'm saying is, well, it might be fast to issue an order that's kind of summary. It's not legal under 17A. A final decision by
that's what-
definition there has to have findings of fact and conclusions of law. So-
Could we, I agree with that too, but for process purposes, could we send that recommendation to the Rules Committee and then have them chew on it and bring it back to us rather than just approving it now?
Oh, no, we'll have to go through the rules process. So I just kind of wanted to flip things around and get people's input before the Rules Committee brought something back. But if people are amenable and don't have other thoughts about it, would just repeal it, that's what the Rules Committee will write up to do.
Thank you.
And I'll also note, just out of curiosity and because I want to know how frequently it's been used, I've already had the attorney at the Ethics Board, he's starting to look into how frequently we have used it and also
That'd be
following
great.
up to see if he arrives at the same conclusion as you, which I suspect he will. And then we don't have our first board meeting until next month, but that'll be an issue I'm going to raise with us because I think it's a worthy conversation to have over there as well.
We'll just look at final decision under 17A. Who will
Yep.
tell you, you need those little details. Second one, Zach, adding a rule stating a complainant may withdraw their complaint.
This was, the idea originally came from Margaret, since she has much more institutional memory throughout the Klein case than I do, obviously. My understanding and recollection is that one of the issues with that was that Mr. Klein was unable to withdraw. I think he was going to be unhappy with the board's final order or something along those lines. And I think her concern was procedurally, if it's not clear that he can withdraw or give someone else in the future the option to do so, then it might result in some unnecessary prolonged litigation. And I know, what one was it? We had one just last month where it was the Hoyt case with Davenport Civil Rights Commission, where everything had been worked on and then at the very last minute they wanted to withdraw, and I know that the board voted to allow that withdrawal, but I can't find anything where it is codified saying that they either can withdraw or that the board needs to approve it or anything. It was just kind of put out there, and the procedure was almost made up on the spot, it seems.
But they also decided to turn the record over.
That's correct.
So that,
Yeah.
Now, and of course, I'm the contrarian here. I just would like you to think, we let complainants withdraw, but, we don't have the ability on our own motion to do anything. So what if you had a situation where you had a complainant who wanted to withdraw their complaint, they had resolved it with the city, but we didn't think what the city did follow the law. That's my concern about allowing the complainant, basically us not using our ability to use that case to come to a final conclusion that we think is consistent with chapter 21 or 22. Arguably, it's not going to happen a lot, but we do not have the right on our own motion, I don't think, or at least that's my reading, to take any action if we think there's something wrong out there, even if a complainant resolves it on their own.
Is the solution then, if somebody wants to resolve, that it takes the board's approval, and we wouldn't approve if they're gonna?
That's what, that is what I'm accustomed to. I'm just a worn-out utility lawyer, but sometimes the utilities board wouldn't let me withdraw things. And, it's always bothered me that we don't we don't basically take some action when someone wants to withdraw a case.
Well, we can take that up at Rules Committee, but I think requiring some approval by the board under a rule to allow withdrawal would
To me, I think
solve
that
that.
would be the best practice, both, I guess, from an administrative law perspective and also looking into the fact that we don't have the right, I don't think on our own motion, and maybe someone disagrees with me, to take some action.
Do you mind if I make a comment on this?
Sure.
So in your statute, there's this election of remedies provision, and so a party can choose to go enforce chapter 21 or 22 in district court, or they can come over here. If they come over here, that pauses any litigation that might be pending in connection with the same set of facts. And so I think you want to think about that too, right? If you were to just let somebody withdraw when they've elected this remedy, I'd have to look back at the code. But I think as you're figuring
They
out what
might
to
be barred from going to court, in other words, is that what you're saying?
I don't know if they would be, or I think Margaret has said she has allowed people to withdraw in order to go over to court.
Okay.
But I guess as a board, if you feel like, well, this is in our hands now, we're already sort of heading down a path, you want to keep it here, then you would want to have the ability to approve a withdrawal.
95% of the time, we'll probably just accept any withdrawal, but there may be that case where we would want to keep that live and open.
Right. That's kind of my point.
Well, it was easy in Zach's case since they turned the record over, and that kind of mooted the whole thing anyway. The way this is written, though, Zach, what I wouldn't think you could do is have a hearing, decide it's not going well, and then withdraw your complaint. And if we've already gone down the road of having a hearing, I think you're going to get a decision issued.
Right,
You
and I would
can't
think
stop
that whatever the committee decides, it sounds like that there is some desire to implement that kind of a rule. Whoever, if it's going to be Margaret or whoever my eventual successor is, I would think that you would want that language in there specifying at what point in the process you could withdraw and at what point it might be too late. Because, if they file a complaint initially with our office and it's about, oh, they didn't, give me a nice hot pan of brownies when I filed my record request, they call Brett, say I want to file a complaint, they do it, and then Brett or Margaret or someone calls back and says this has nothing to do with Chapter 22. A lot of times I think the withdrawals that the office gets are earlier on in that process.
And after we've sent the brownies.
Yes, of course, yeah.
Well, then I think that's something we should take up at the Rules Committee and try to draft a rule that contemplates those things.
And then the third idea, I think probably the most prolific part of Chapter 22, or any chapter that we deal with here, that gave us the most headaches is 22.7 sub 65, which colloquially is the draft exemption. Both Margaret and I think, feel pretty strongly that there needs to be some clarifying language in the rules, because as the statute is currently written, it is far too ambiguous. I think the meaning of the word draft is just out there for anyone's interpretation, and I know Margaret thought that the language should focus more on what else is in the statute: preliminary, research, speculative, and kind of do away with just draft to get some more clarity, because I don't know how many complaints we had where people were unclear about sub 65 and how exactly that applied. So I think any kind of clarification, I wish they would just rewrite the statute, because that subsection is a mess in every sense of the word. But for the time being, I think there does need to be some clarification.
We can take it up at rules. I think it may be a tough thing to do within the scope of just rulemaking. And I agree, the
Yeah,
statute
you don't
needs to
wanna
be rewritten.
Yeah. And then last but not least, kind of what Julie was hitting on earlier, which I would think you might want to wait a little bit.
Yeah, until there's, because we're going to have a contested case on
Right.
what outside of government means. And whether we want to follow that up with rulemaking in the end, I don't know. But it could be quite a while before we get a final decision, because we'll have another contested case, unless there's a resolution otherwise. Before we go on to the next topic, I want to give Stan a chance to say something. I think people are aware he's just taken a new position.
Yeah, thank you for letting me interrupt your normal flow of the meeting. As you may know, I received an appointment from Governor Reynolds to serve as the Executive Director of the Iowa Civil Rights Commission in late December, and began serving in that role Monday, January 10th. And through discussions with the governor's office and Margaret and Brett, I came to the conclusion that the best thing for me to do, despite my enjoying immensely serving on this board, was to resign my position. I was appointed as a public representative. Now I'm a full-time state employee. And perhaps more importantly, I wanted to devote my full attention and activities to the Iowa Civil Rights Commission. They have had a fair degree of turnover at the executive director position and interim director over the last 4 or 5 years. And I just believed it was best for the staff, there are 22 on the staff, to have a permanent executive director who's solely focused on that work. So for those reasons, I have submitted a resignation from this board. I understand new appointments will be made by the governor in April, so that void should only be a couple of months due to my resignation from the board. But to demonstrate my knowledge of the importance of this group, my first board meeting as executive director of the Civil Rights Commission is tomorrow. They now have started a practice of meeting on the third Friday of every month, and I've already invited Margaret and Brett to make a presentation to the commission on open records, open meeting at our February meeting. So I think that further underscores how much I enjoyed serving here, the importance of the work that you do here, and that I wanted my commissioners to have the benefit of their expertise and knowledge to better serve the public through the work that the Iowa Civil Rights Commission does. So with that, like I say, I really, really enjoy working on this board a lot.
Well, I tried to persuade Stan that he could stay, but I think by the time I talked to him, he'd made up his mind. And I understand your position about devoting full time, but we hate to see you go.
Apology accepted.
Yeah. And I appreciate that as part of my learning curve, which is immense at the Civil Rights Commission. I know that I'm in the presence of a former Civil Rights Commissioner himself here. So, I've studied up a little bit on that. So appreciate your service on that commission as well. So I did turn over my card to Brett before the meeting, I guess, as I showed up. I now have my full-time state pass, so I don't think it lets me into the Wallace building. had a meeting in Hoover yesterday, and I took the tunnel, and I got all the way there, and I couldn't
get
get
in.
in. So I'm learning the limitations of this, but I did think it appropriate to turn that back over, so.
Tell them to turn it on for everywhere.
Yeah.
And then in your honor, we brought chips and water.
Well, thank
You
you.
know.
I wouldn't want it any other way, so thank you for doing that.
Well, good luck to you, I'm sure.
Yes,
Yeah.
I appreciate that, and,
It'll be interesting to watch.
yeah,
Yeah.
I'm really, feel fortunate that I was appointed and really want to do a good job, so I'm going to work hard at it. Hopefully that'll show.
I think you'll enjoy it. I certainly did when I was
Yeah,
on the
I
commission.
think so. I've met with all but 2 of the staff members. I have one this afternoon and one tomorrow morning before a board meeting, so in less than 2 weeks, we'll talk to all the commissioners, all the staff, one-on-one. Starting to get a better idea of how things operate, but it's a good group. It's a good group.
Sure. Well, you're welcome to come attend the meeting
Yeah.
anytime.
Well, like I said, I'm going to take your staff for a couple hours in February to help us out, so I appreciate that. And if any of you want to show up for that meeting and chime in, that would be fun too. So.
Stan, just don't steal any of our employees, okay?
Yeah.
Right.
Let it be pointed out that the IPIB does train small agency directors for the state of Iowa.
Yeah, exactly. That was my point.
You're like those successful college coaches that have their assistants go out.
Yeah. Well, congratulations.
Yeah, once again,
Good luck
thank
to
you.
Thanks for taking that on.
Take some of the heat off me. I'm not the only one leaving.
Yeah, I really, I understand why he doesn't want to try to do both.
I do
but
too.
it seemed good. Okay, are we up to cases involving board deliberation?
Julie, there may be one more rule.
Oh.
In last month's minutes, under the board chair, the last item put on a future agenda the topic of addressing the late release of records. Remember, we discussed that.
Oh, we did. I'm sorry.
And I suggested that, but I'm very comfortable having that go to the Rules Committee and we talk.
Well, I mean, this isn't an exclusive list because I assume because I think we're going to have to deal with the intervention issue, which wasn't, I don't think that's subject to a remand, is it? In the
No, I thought that was decided.
case, the intervention and contested case issue, I mean, that might end up on the rulemaking docket as well.
They note that he could have, but obviously they didn't
Yeah,
require that he do so to have standing. And, Rick, I'm glad you mentioned that, because I thought that's something the Rules Committee could at least talk about rules where what factors would justify delay. I don't think we could probably do a rule that says, this many days or you'll burn in hell or something. But I think that's a good idea. Okay, now, cases involving board deliberation or action. We'll start with Mr. Brubaker.
And I'll defer to Brett if he wants to take
That's
on this
case 21 FC 0114. Mr. Brubaker on December 7th filed a complaint alleging Broadlawns Medical Center violated Chapter 22. He stated that they refused to provide information to him, but he was unable to provide details on when he requested answers to his questions or if he had received any response. On December 13th, legal counsel for Broadlawns responded to the complaint by providing a copy of the letter sent to Mr. Brubaker that answered the questions he posed. The letter also indicated that Mr. Brubaker requested this information by voicemail on December 7th. Requesting answers to questions is not considered a public record request unless the questions include a request for identifiable public records as defined by the Iowa Code. Broadlawns provided the answers to Mr. Brubaker's questions in 4 business and 6 calendar days. Even if his request had been identifiable records, there was no reasonable delay by Broadlawns. So this complaint does not meet the requirements of 23.8. Jurisdiction appears legally sufficient or merit. So the recommendation is dismissed.
In fact, they went beyond what's required under 22 by just answering his questions, even though there were no records to be produced. Do we have Mr. Brubaker on the phone? No, or anybody from Broadlawns?
Motion.
Yes, this is Joe Mosier from the Finley Law Firm on behalf of Broadlawn.
Okay, would you like to speak to the board?
I have no comments. Thank you all for the opportunity, and I appreciate the recommendation. Ask the board to approve it. I agree with the remark that Broadlawn's attempts to go above and beyond the requirements of the open records by responding to the voicemail.
There's no further discussion. Do we have a motion on the dismissal order?
This is Joan. I would move to approve.
Okay. We have a second?
This is Monica. I'll move the second.
Okay, moved by Joan, seconded by Monica. All in favor of approving the dismissal order signify by saying aye.
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 Any opposed? The dismissal order is approved. Chad Brubaker, number 2.
On December 7th, Mr. Brubaker filed a complaint. This is complaint 21FC0115. He filed a complaint alleging that the city of Waukee violated Chapter 22. On December 8th, Mr. Brubaker was asked to provide a copy of his request for records, and for a request of any response that he received, Mr. Brubaker did not provide any additional information to support his complaint. The city was notified of the filing of his complaint on the 8th. On the same date, the city attorney responded that the city had no record of any record request submitted by Mr. Brubaker and requested additional details. Council added that Mr. Brubaker was present at a city council meeting on that date and made a statement during an open forum around the time noted on the complaint, but the record request was not made. In response to the email from legal counsel, Mr. Brubaker filed a short reply saying hiring a lawyer doesn't exempt a municipality from Chapter 22. On the 13th of December, staff again requested Mr. Brubaker provide additional information in support of his complaint, advising him that information was necessary. No additional information was provided. So the recommendation is to dismiss since this complaint does not meet the requirements of 23.8.
Move approval of the dismissal order.
Well, I assume Mr. Mosier has nothing he wants to add, but let me give him that opportunity.
No, this is
Mr.
Wadis.
Britt.
Yeah, Waukee.
Yeah, Mr. Breck, Steve Breck is
Oh.
the attorney.
Duh. Sorry.
Sorry.
No problem. This is Steve Brick for the City of Waukee. I don't have anything further to add to what's already been said. City doesn't believe it ever received any open records requests. Mr. Brubaker, and of course, hasn't been able to identify through the submission of further information from Mr. Brubaker what he's complaining about. So we agree with the disposition.
Sorry for confusing you with Mr. Mosier. Okay, now, Keith, did you move?
I'd move we accept the dismissal order. Second.
Moved by Keith, seconded by EJ. All in favor of approving the dismissal order signify by saying aye.
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 That was Keith and who?
EJ. Any opposed? Dismissal order is approved. The next
Thank you.
case is Marion Davenport and the Lorimer City Council. And which of you wants to talk about that?
You know it?
I can, if you want. I'll defer to the people who still work here.
No, that's fine. On December 14th, And the reason we hesitate, we're looking at each other is because many of these, when they're pretty straightforward, Margaret kind of takes a look at. Actually, Logan, did you work on Logan?
I've looked through some of these, but
Okay, so I'll read the order as it is. On December 14th, Mary Davenport filed a complaint. This is complaint to 21 FC 0121, alleging that the city council violated chapter 22. Ms. Davenport alleges that the city council meets the first Monday of each month and that the official newspaper for the council is the Afton Star Enterprise. She alleged the council had held a regular meeting on November 1st. As of December 9th, the minutes of that meeting had not been published in the Afton Star Enterprise. Ms. Davenport also alleged the city clerk also failed to publish minutes in 2014 and 2015. The Lower Mars City Clerk responded, stating that the November 1st meeting minutes were published. Iowa Codes 21 and 22 do not set requirement for publication of minutes of governmental bodies. That's Iowa Code Section 349.18 sets the requirements for publication. Pursuant to Iowa Code Chapter Section 23.1, the IPIB is granted authority to address complaints concerning violations of Chapter 21.22. Therefore, the IPIB does not have jurisdiction over allegations concerning violation of Section 372.13. So this is a dismissal order that does not require or does not comply with our requirements.
And do we have Ms. Davenport or somebody from the Lower Mars City Council on the phone? Nope. Questions or comments from the board? No? Steam ahead. Do we have a motion?
I move to accept the dismissal order.
Second.
Moved by Rick, seconded by Susan. All in favor of approving the dismissal order signify by saying aye.
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 Any opposed? The dismissal order is approved. The next item on our agenda is Becky Eltz. I hope I pronounced that right, Ms. Eltz.
You did.
Thank you. And the Amana Colonies Land Use District. Zach, are you going to talk about this one?
I'd be happy to. This is 21 FC 0117, Becky Eltz, concerning the Amana Colonies Land Use District. Ms. Eltz, back on December 9th, filed a complaint saying that the Land Use District violated Iowa Code Chapter 22. Ms. Eltz alleged that on 4 different occasions, November 4th, 10th, 12th, and December 9th, she requested copies of changes of use permits from the Land Use District. She added that she also made a verbal request for the meetings another time on November 22nd, and that she only received copies of the rezoning applications in lieu of the change of use permits. She also alleged that she requested copies of the district's meeting minutes that indicate a vote by the Historic Preservation Commission or the Board of Trustees that allowed the district to rezone a specific property without a public hearing. Those records were requested on November 16th and December 9th. Legal counsel for the district responded to the complaint on December 16th, noting that the district operates as a governmental body that is bound by the open meetings and public records laws, though the district understands that the IPIB has not truly evaluated the applicability of Chapter 21 and 22 to the district. Counsel also stated that the records requested by Ms. Eltz do not exist. She goes on to talk more specifically about the first request, saying that no change of use permits were issued for the Millwright Hotel, which is the property at issue. Ms. Eltz was provided with copies of the request for rezoning and approval, which approved the change in the use of the property, and no other permits were issued. She also added that there were no meetings, so there were no minutes of the meetings that Ms. Eltz sought to obtain. Ms. Eltz replied on December 17th, stating that she was not informed of the information provided by legal counsel until she received the communication made on December 16th to the IPIB. She also noted that she had been informed of this at the time of her initial record request or soon after. If she had been informed, she would not have continued to request them. She provided additional comments concerning the procedures, which are not subject to Chapter 21 or 22, and the issues in this complaint do not establish a violation of either the open meetings or public records laws. However, it is clear that the district, had it responded to Ms. Eltz earlier, could have avoided the filing of this complaint. I will also note in a footnote there that the board would adopt the position of the district that it is a governmental and government body for the purposes of this order and only this order. This does not meet the requirements of Section 21.8 because it is legally insufficient and it does not have merit. And it looks as if Ms. Eltz and potentially Ms. Bergen as well have filed additional comments, which are attached in the board packet.
She wrote to me. Were those included? Should have been.
I don't believe so.
And then I
These
know
are what were, when they were requested, do you want anything included to the board? That's what was submitted there.
She did email me with additional comments, and I forwarded them on to Margaret. I thought they'd be included as well.
My mistake then.
Ms. Eltz, would you like to address the board?
Yes.
5 minutes.
Yes, I would. I have a brief statement. Can everyone hear me okay?
Yes.
Yes, loud and clear. Thank you.
Okay, thank you. I did file the complaint that you have there before you against the land use, the Amana Colony's land use district, because they did not provide me the requested public documents as is required in Chapter 22. Included with my initial complaint were copies of 6 emails to ACLUD for the requested documents. ACLUD did not respond to my request until November 16th, when I was handed 4 pages of documents, none of which were the documents I requested. Ms. Burgess is suggesting that I was told the documents I requested were included in the 4 pages that were provided to me. The documents that I was handed on November 16th did not include a change of use permit or the meeting minutes, and nor were either of these requested documents addressed in any of the 4 pages. I provided this board copies of those 4 pages that I was given on the 16th and an explanation of why none of the pages addressed the actual documents I was requesting. An important note here is that I have been in touch with 2 previous ACLUD administrators, and neither agree with ACLUD or their legal counsel that the change of use permits were part of the rezoning application for the Millstream Hotel. Since my complaints were filed, we were first told on December 15th by Ms. Shealy, who is the ACLUD BOT chair, that the documents I requested did not exist. That was then followed by Ms. Burgess, ACLUD's legal counsel, in her response to the IPIB complaint, that even though I was provided the documents, the specific documents I requested did not exist. These 2 admissions were the first I had heard that the documents I was wanting didn't exist. Another important note here is that both admissions by ACLUD were well after I filed my complaint with IPIB. And just for purposes of understanding the significance of the documents I was requesting, I'd like to provide just a little bit of insight. In my opinion, the admission from ACLUD that the documents I requested did not exist happened because ACLUD realized that the IPIB complaints filed against them could possibly force ACLUD to admit that they did not require a permit for a property owned by the Amana Society. In other words, a property owned by Amana was not required to fulfill the same requirements that every other business in Amana had to. This admission, if you will, was now going to be made public. However, even though that admission is a result of my IPIB complaint, it has absolutely no influence or bearing on whether or not ACLUD violated the IPIB 22.4.2. They did. My complaint addresses the fact that ACLUD was asked to provide public documents, or if not, a statement as to why the documents could not be provided. ACLUD did not do either. In my opinion, ACLUD has violated Chapter 22 by not doing so. To further examine this complaint, I would ask the board to consider the initial and the revised reports provided by Director Johnson to dismiss my complaint. In both reports, my words have been made to imply that IPIB does not have jurisdiction over ACLUD's mishandling of their own governing procedures. Director Johnson's characterization of my words are misleading. I am not asking the IPIB to make a determination about ACLUD's violation of their own ordinances. I'm asking this board to address ACLUD's clear violation of IPIB 22.4.2 by not fulfilling my request for public documents, nor letting me know the documents did not exist until well after this complaint was filed. Thank you.
Okay. We have Laura Burgess on the phone, the legal counsel for Amana Colonies. Would you care to speak?
Thank you, Board and Chair. The Land Use District agrees with the entry of the dismissal order, and just as a clarification, we did provide information from the administrator, Richard Booty, who was there in the office on November 16th, which was the day that documents responsive to Ms. Elt's request for as the district interpreted her request as anything indicating the change of use, as I think is uncontested. There was not a specific change of use permit because the change of use in the property was done through the rezoning process. So the documents showing the rezoning were presented to her on November 16th, and the other issue was meeting minutes for a meeting that did not occur.
Anything further?
No, thank you.
Questions from the board for Ms. Eltz or Laura Burgess? Discussion by the board?
I would just like to thank our intern Logan. I have a lot of issues with whether this entity was a government body, because if you look at the history of it, it was really intended to replace private property rights, and there's that language in that chapter about it's a body corporate and politic. Mm-hmm. And to me that means a corporation and a political party and not a governmental body. And he really helped. He did a lot of research, and he recognized my concerns and actually found other references to corporate and body politic in other provisions, basically, of the law concerning counties. That really helped me to address that concern I had about whether this is even a government body. I mean, I'm happy. I think it is subject to 21 and 22.
Thanks, Logan.
Yep.
Ms. Burgess, why did it take your entity that long to respond that there are no such documents?
I think the land use district has a part-time administrator, and under this time period, I believe Ms. Elt's first request was received on November 4th, and the district was in the process of switching over to Mr. Booty, who's the current administrator, and was training 2 days a week on, and so that week, November 2nd and November 4th would have been the days that he was there. The documents in question relating to the change in use of that property, I believe, were from the year 2018, so it took some research to locate where the responsive documents were. So it was 8 business days from the first request of November 4th until the disclosure of November 16th. So I acknowledge that is not as fast as we would like, but that was the circumstances leading to that time period.
Thank you.
Further discussion?
May I make a comment here? This is Becky Eltz.
Yes, go ahead.
I want to comment on what Ms. Burgess just said. When I initially asked for the documents on November 4th, I actually had to go to ACLUD office, who had a previous administrator in there, plus the current or the new one that they had just hired administrator there. And when I asked them, they were very reluctant to give me anything. Finally, she made 4 copies, at which she charged me $5 to give me 4 copies of documents that I did not ask for. if you were able to see the documents that I provided to the board, you will see that a change of use permit has an array of questions on it that were not addressed in a rezoning application. And in speaking with both of the previous ACLUD administrators and actually the one who was the current administrator of the 2018 when this whole rezoning application occurred, they are two separate things. They're not one and the same. A change of use application is not a rezoning application. So for them to hand me 4 documents and say, here you go, that's not what I asked for. And they did not tell me that those documents did not exist until well into December and after I filed this complaint. Had they told me way back when, I probably would have not kept requesting them, even though it would have been required of the Amana Society to do so, to file that change of use permit. But the documents they handed me were not change of use, were not the documents that I asked for. And they did not come forth with the admission that those documents did not exist until well after this complaint was filed.
Thank you.
Thank you.
Thank you. Ms. Burgess, as I understood your comments, you thought the rezoning process obviated the need for the procedure that Ms. Elves was talking about?
That's correct, yes. That would have resulted in the specific change of use permit, yes.
Do you mean that by rezoning, that use would have been allowed without a permit? Is that what you're saying?
The actual documentation, so trying to be responsive to the public records request, the documentation that would have shown the change in use of the property was reflected in the rezoning documentation, as there was no change of use permit issued. And I don't know if Richard Booty is on the line. I know he was planning to, but I believe he was in the office that day that Ms. Eltz came in on the 16th.
Yeah, actually, this is Richard Booty. I am on the line here.
Do you have some comments, Mr. Booty?
No, I really don't have anything to add. I think that Laura Burgess's response from her letter of December 16th pretty much sums it up. I will say that I was in the office when the 4 pages were handed to Becky, and she said, this isn't the paper I expected, and then Ellie said, this is the paper that covers the transaction. So we provided her the paper that covered the transaction.
Thank you. Further discussion from the board?
May I respond to that?
No, I think we've had enough input. Thank you. Any further discussion from the board? Do we have a motion?
I'll move it. Second.
You're moving to approve the dismissal order. Moved by EJ, seconded by Keith. All in favor signify by saying aye.
Aye.
Aye. Aye.
Aye.
Any opposed? The dismissal order is approved. Thank you for your time, Ms. Eltz, Ms. Burgess, Mr. Booty.
Thank you.
That brings us to Michael Funk, and Cerro Gordo County Sheriff.
Yeah, on December 22nd, Michael Funk filed a complaint. It's number 21FC0123. It alleged that the Cerro Gordo Sheriff's Department violated chapters 21 and 22. He alleged that he had made public record requests to the sheriff on December 31st, 2020, January 25th, 2021, February 12th, 2021. He received various responses and requests for additional information. On the 21st of March, 2021, he was informed that he had received all public records and that other records were confidential pursuant to Iowa law. Iowa Code 23.7 requires that the complaint be filed within 60 days of the time the alleged violation occurred. More than 60 days elapsed between the denial of the requests of records and the filing of the complaint on December 22nd, 2021. The IPIB therefore does not have jurisdiction over this complaint. Mr. Funk did not provide any information or allegations concerning open meetings violations, since he had originally claimed both circumstances. So Iowa Code Chapter Section 23.8 requires the complaint be within our jurisdiction, appear legally sufficient, and have merit. This complaint does not meet those requirements, and therefore the dismissal order has been dropped.
Do we have either Mr. Funk or anybody from the Cerro Gordo County Sheriff's Office on the phone? Nope. Board discussion. Seems fairly straightforward.
I would move approval of the dismissal order.
Okay. Do we have a second?
Second.
Moved by Susan, seconded by Keith. All in favor of approving the dismissal order signify by saying aye.
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 Any opposed? The dismissal order is approved. That brings us to Ellen Heather and the Mitchellville Library Board.
You work this one?
Yeah, I can do it.
You want the file?
No, I don't think I'll need it. This is 21 FC 0110, Ellen Heather and the Mitchellville Library Board. Ms. Heather filed a complaint on November 23rd alleging that the board violated Iowa Code Chapter 21. She alleged that on November 24th, the board president sent a text message and an email to Ms. Heather, who I believe is the director of the library, and all of the other board members. Copies of the text and the email were provided to the IPIB. Text message was also sent to 6 people and stated that the sender planned to raise specific questions at the next board meeting. The email was from the same individual, sent to Ms. Heather and copied to the other board members, and again listed the 3 questions she planned to raise at the board meeting. The sender asked Ms. Heather to prepare to answer her questions and prepare information for the meeting. There was no indication that anyone responded to the text or the email. Neither communication requested a response from the board members. An affidavit was provided by Ms. Alsop stating that the email and text were mistakenly sent to all board members. She added she did not receive any response from the board members. And then both sides submitted background information concerning the financials of the library and an ongoing audit of the city, which is beyond the scope of Iowa Code Chapters 21 and 22. Iowa Code Section 22.2 Sub 2 defines meetings for the purposes of compliance with open meetings laws, and the factual situation described in Ms. Heather's complaint does not meet that definition. It does not appear that the board gathered or deliberated or took any action in the communications of the email or text message. One member of a governmental body sending information to other members is not a gathering of the majority. Now, if the majority had responded to the text and email and engaged in deliberation, then a meeting might have occurred. And it is prudent for government bodies to advise members to avoid engaging in deliberation through electronic means, such as text or email, without following the requirements of an electronic meeting set forth in Section 21.8. Therefore, it does not meet the jurisdictional requirements of Iowa Code Section 23.8, and Margaret recommends dismissal.
Okay, is Ellen Heather on the phone? I think we did have somebody from
Amy Beatty.
from Mitchellville.
On behalf the city attorney, as well as Tammy Delabo, the city administrator, on the line. I don't think we have anything additional to add, and just request the board support for the dismissal.
Okay, that was succinct. Any board questions or comments?
You know, this dismissal order is fine. You know, we seem to get a lot of complaints about library boards because they probably don't meet very often. I am a librarian. I went to library school before I went to law school. Librarians are very particular, and they try to do things right. You know, this complaint wouldn't have gone any further if Mrs. Heather had just said, hey, stop communicating, we can't. I wonder if we should go to the Iowa Library Association sometime and do some training for librarians, because they will take very seriously anything like this. At least, that's the way I've always felt librarians operated.
I would add to that I am aware that the state library librarians are very in tune with chapters 21 and 22, and they do provide resource to their librarians around the state, because oftentimes we'll hear that the librarian's been in contact with the state, and then the state's went ahead and suggested, go ahead and bring it to us for review. But so I don't know the extent of their training, Susan, but I do know that they're very in tune with 21,
In
22.
this case, I think Ms. Heather could have just said, please don't communicate this way, and maybe we wouldn't have had to have this complaint. So I don't know if she didn't have the training or didn't feel comfortable saying that, but I would just suggest we get some more training for librarians. They like to be trained.
What is the concern about the communication?
Well, it looks like the librarian, I think you said she's a library director?
I know she works for the library. I don't know
Okay, the librarian
what her
is the
position is,
one
but she
who
works
filed
there.
this complaint. And I may not be reading this right, but the board president sent a text message to her as well as others. And then there was a follow-up text message about that this board president was going to raise specific questions. It doesn't sound like Ms. Heather, she could have done a peremptory strike and said, please, this is not an appropriate way to communicate. Do not communicate any further to all the board members. Then there wouldn't have been an issue.
And I would add that I believe that Ms. Heather's concern is that there's business of the library being taking place outside of meetings through email communications. And she happened to be mistakenly included on this email and then took that as an identifying point that
she couldn't.
that something, this
Okay.
is meeting her suspicion.
Okay,
But
it just seemed that, I've been on boards when someone sends an email, even about the meeting time to everyone on the board, and the administrator always just says, don't send everything to all the board members, and you can peremptorily cut out any further potential discussion just by having the government officials say, hey, please don't communicate this way.
Yeah, but unless you're all at the same time communicating it by electronic means, there's no violation of the law.
Yeah.
And I guess I don't see any problem with somebody emailing all of the members. And when we get emails and it just lists me as getting a copy, I always wonder who else did. And I think it's to avoid, Margaret doesn't want everybody to be on the email at the same time and generate a meeting, but it kind of annoys me because I'd like to know who else was copied. And people should at least keep that fine point in mind that unless you're all together emailing and there's actually a majority gathering electronically, there's no reason why you can't email everybody or text everybody with a message.
Well, I know that within the office, we typically tell folks, try to avoid sending to all in the event that it generates responses.
It can generate responses,
and then
just so they're
generates
not-
responses repeatedly, therefore creating a discussion, a deliberation on an issue.
It's not going to be a deliberation unless everybody's on at the same time, like you're in a chat room, or you're all emailing simultaneously.
I've been on a lot of boards, and it seems that whenever anything like that starts, the administrator always says, or even if before anyone starts communicating, they want to be seen. No one really, all board members are always quickly reminded not to do email between the whole board, because one email then can lead to pretty easily to deliberation.
Well, I think it would be kind of uncommon. I can understand not wanting to carry on the whole discussion and then get to the board and nobody has anything to say because you've already done it. But there's no violation in
No, I
emailing the
understand
group.
that, but, we could have just cut it off by saying, let's talk about this at the meeting, let's not talk more about this on our communications.
My experience is the practice that Susan describes is general among bodies and boards I've been on. City attorney has them put, don't communicate, don't respond. If you got a question, call me.
Yeah, that's usually what they put, please don't respond to all,
Yeah.
call me. Just
So I
as
think
good
it's a
reminder.
caution. I'm not arguing what the law is. I'm just saying that I think that's
No,
something.
and I think this is fine, I'm just thinking that, I think we need to have, I suggested to Margaret this would be a good topic for a column. gives some general advice.
And I won't object to it if what's
Yeah.
clear is that you should get all the discussion vetted before you get to the
Yeah,
board
yeah.
meeting, and then nothing's discussed in front of the public.
Yeah.
But it's just kind of rubs me the wrong way that people think you can't email a group, because you certainly can.
And they can say, yes, I can't meet on this day, to the whole group if necessary. I mean, there are communications they can have, but I'm getting way off track here, so.
And I guess I'm the only one who's wants to champion the right to copy everybody on an email.
No, but that's a good point. Keith, have they ever had an advisory opinion related to the topic that you can recall?
I kind of agree with what Julie said.
Okay.
I think if people, city council or somebody, they assume that I just kind of assume there'd be some communications, but I do this, or are you have your vote or whatever. I mean, I don't know about sending that to everybody in the council or something. I've never encountered that.
Well,
I can recall.
I certainly wouldn't encourage people to use email or even phone calls to resolve discussion before you get to the meeting.
Maybe Woodbury County is a bad exception, but I know we have officials in Woodbury County who go around and say, you two can't talk to each other, you're deliberating. And so I think it would be good to try to have an advisory opinion or a column or something on this topic.
I don't ever remember it being a problem.
No, I don't think it's a problem. Like I say, I think most of the municipal attorneys generally, I think, are just come down by the side of conservative,
Yes.
because they're dealing with people who may not know the law. Just say, got any questions, call me, don't call the other guy.
And a lot of times, if there's something, development or something that's complicated, I mean, you'd send out information before a meeting so people would have it, like we do, that you have a chance to review whatever it was that was going to be discussed.
It avoids the issue, it avoids the problem of the accusation by the public that you've gotten together, I think.
Well, to me, not to beat a dead horse here, but to me, it's like people thinking you can't gather, or go out and have a beer after a meeting. Of course you can.
Well, and I'll note that the communications at issue in this complaint were addressed to Ms. Heather, saying, I want you to be prepared to answer these questions for the board meeting. So it wasn't directed to the other board members.
And it wasn't really deliberation, or it wasn't inviting deliberation.
Yeah, it did not invite anything.
They all got it by mistake.
Yes.
Or not by mistake.
Yeah.
Okay. No, if anybody wants to end this discussion by making a motion, that would be fine.
I'll make the motion to approve this. Second.
Moved by EJ, seconded by Keith. All in favor of the dismissal order signify by saying aye.
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 Aye. Aye. Aye.
Any opposed? I didn't hear Barry in that, but
Oh, I heard him.
did you? Okay. Our next item, and I think we have a motion to continue on this. Ren Hoffman.
Yeah, this is an informal resolution that I'd worked on. This is the second request for a continuance. It's requested by the city attorney. They have complied with everything. The city attorney would like, though, the city council to review their approval of the informal resolution. He felt that their heart wasn't in it, that he wanted them to he wanted to revisit their consideration of what the informal resolution meant for the city. And so, and he did not get the business taken care of prior to this meeting, so he requested another continuance. And we see no reason not to offer that.
Okay. So we need a motion granting a 4-week continuance
Correct.
until February 14th.
So moved.
Second.
Moved by Susan, seconded by Rick. All in favor of the continuance signify by saying aye.
Aye.
Aye. Aye.
Who made the motion?
Aye.
Susan, second by
Seconded by
Rick.
Rick.
Thank you.
Any opposed? Nope. That brings us to Cody Kite-Worth
Yes.
and the Bonaparte City Council.
And I did have this one, Brett. So,
Name file.
no, I don't think so. Yep, this is 21 FC 0116. This complaint was filed by Ms. Kiteworth back on December 8th, alleging that the council held an improper meeting under Chapter 21 because it was held via Zoom without proper notice. Ms. Kiteworth also alleged during the meeting that a council member asked a question about a matter not on the agenda. She also alleged other violations of Iowa Code Chapter 68B, which includes that the council members are attacking, threatening, and defaming citizens on social media. Those are not Chapter 21 or 22 issues. The city clerk responded to the complaint on December 29th, stating that the meeting was changed to an electronic meeting because a Veterans Day supper was scheduled to be held at their typical meeting location. And she stated that the proper notice for an electronic meeting was posted on the city's website, the Facebook page, on November 8th, and then at the post office, the Opera House, which is their regular meeting location, and the bank on November 9th. A copy of the posted meeting notice was provided. The notice included all the information necessary to attend the electronic meeting. The notice included the information required by Section 21.8, and the minutes then included a statement explaining why an electronic meeting was necessary under 21.8 sub 1 sub C. And Margaret correctly points out that council members can ask questions and make statements during an open meeting as long as no deliberation or action is taken on matters not listed on the agenda. Section 21.8 requires that a complaint be within the IPIB's jurisdiction, appear legally sufficient, and have merit. This complaint does not meet the requirements. Therefore, her recommendation is that it be dismissed.
And did we have either Cody Kiteworth or somebody from the city council on the phone? Nope. Board comments or discussion?
Where was the notice about the change posted? Where is the meeting usually held?
The meeting is usually held at the Opera House, and it sounds like it's the only suitable gathering place in town, which is why the Veterans Day supper was being held there.
Thank you.
Board comments? A motion?
I move acceptance of the dismissal order.
Second. Moved by Keith, seconded by EJ. All in favor of approving the dismissal order signify by saying aye.
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 Aye. Aye.
Barry?
I didn't hear Barry.
Yeah, I didn't hear him either.
Barry, did you vote?
Yes, I said aye.
Okay.
There we go.
The dismissal order is approved.
Then I can do the next one too, Brett.
Got it.
That takes us to Jeremy McGrath on the Chickasaw County Ambulance Council.
This is case number 21FC0103 filed by Mr. McGrath on November 4th, alleging a violation of both Chapters 21 and 22 against the Ambulance Council of Chickasaw County. Mr. McGrath alleged that he made a record request for a copy of the draft request for proposals, or the RFP, on August 3rd, and such request was denied on that date. He also alleged that he made another request for the RFP and the emails showing council members discussing the draft on August 31st. He alleged that the denial constituted a violation of Iowa Code Chapter 22. He also alleged that 3 of the 9 total members of the council had engaged in discussion by email concerning the drafting of the RFP at an unknown date, violating Iowa Code Chapter 21. Legal counsel for the council responded to the complaint on November 19th, stating that there was no violation of open meetings laws because 3 members of a 9-member council is not a majority, so it would not meet the definition of a meeting under 21.2 sub 2. Regarding the request, legal counsel stated that the draft RFP would be confidential pursuant to Iowa Code Section 22.7 sub 65. Council further added that the only email sent to all council members was a copy of the draft RFP, which is, again, held to be confidential pursuant to sub 65. So any responses to that email would not have been sent to all members of the council, because if you look at the emails, all the members were BCC'd. So if they were to hit reply, it would not go to all 9 council members or even all 3 committee members. The request for the proposal was approved on October 6th, and it was made public thereafter. The council also expressed concern that releasing a copy of the draft RFP to the complainant prior to the general release of the RFP would give the complainant an unfair advantage in the bidding process. And it's not a footnote, but I will add that Mr. McGrath does operate or work for an ambulance service. Mr. McGrath then responded that by making drafts publicly available, all the potential bidders would have the same information, so it would be a level playing field. Iowa Code Section 23.7 requires that a complaint be filed within 60 days from the time the alleged violation occurred. More than 60 days has elapsed between the denial of the request on August 3rd and the filing of the complaint on November 4th. Resubmitting additional requests for the same document cannot be used to avoid the jurisdictional requirement. Therefore, the IPIB does not have jurisdiction. And then open meetings laws were not violated by the 3 members of the council because they are not a majority of the council. You can see the definition in the footnote there. Therefore, Margaret's recommendation is that the complaint be dismissed as beyond the jurisdiction of the IPIB.
I don't think anybody had called in, but do we have either Jeremy McGrath or someone from the Chickasaw County Ambulance Council on the phone? Nope. Comments from board members?
Was the draft used in the final preparation, the final approval of the matter?
You mean?
There was a draft RFP.
Yeah.
It was a draft because it wasn't final or approved?
It was a draft, yeah, because it wasn't final. And then when it was brought to the full council, instead of just that drafting committee that the 3 members made up, it was then approved on October 6th. So the record has been released for some time at this point.
The same draft became the document?
That's my understanding.
Okay, how about...
This is Barry. I have a question. I ask, what's the basis of the point that resubmitting a new request doesn't get you a second shot at the issue?
I guess, I don't know if there's some legislative background there. I know that I think it's more narrowly applied to just the same requester. So, if I had requested the same document a month later that Mr. McGrath had requested, they can't turn me down, but I don't know what the reasoning was behind that.
Well, otherwise you could just keep reviving the request.
Right, and then the whole 60-day limit, which might be 90, we'll see, then it would be moot. Yeah. Then we could have complaints from 2010.
As long as you keep asking.
I'm just curious why that wouldn't just be considered a new request that starts the 60 days again.
I
don't know. It's the first time I've heard that.
Right. My understanding was always if you're resubmitting it, you're the same person, you're resubmitting for the exact same thing. Is it really a new request just because you resubmitted it? You were already denied it. To me, it seemed materially the same as what you already got an answer to.
I mean, there's no point in having a time limit, I don't think, Barry, if you can get around it by just asking again.
I don't think we've ever memorialized this. I mean, not that I think we need to worry about it here, but you could ask for that document and any minutes or any additions since that time to make it a new request. So I'm not saying we take it up here, but it's probably something at some point we should look at.
Yeah, I'm going to add it to the rule memo.
Okay, thanks.
Were there any other emails or documents in connection with the RFP draft?
No, and that's why that second request that was filed on August 31st is materially the exact same, because the only records that would be provided in those emails, aside from to, from, and the timestamp, is just the actual document itself, which was already requested on the 3rd.
Thank you.
Further discussion? How about a motion?
So moved.
Mr. Barry, I vote to approve the dismissal order.
I will second that.
Okay, excuse me, moved by Barry, seconded by Susan. All in favor of approval of the dismissal order signify by saying aye.
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 Okay, dismissal order is approved. That brings us to Vanessa Miller in the University of Iowa. We have an informal resolution report.
Yeah,
Familiar?
I'm not sure how much background the board wants. I know that this matter has come before us before.
And we had a fairly lengthy discussion of it, that people may remember it, the process of hiring people without a search process and the unfortunate characterization of the trailing spouse. There's justification sometimes for that.
Yeah.
So maybe if you want to review the terms.
Yeah.
On the back third page,
Yep.
the terms are set out.
So the terms are that the University of Iowa will agree that certain portions of search waiver requests are public records. They will adopt a search waiver release policy that will require the release of search waiver request forms, package comments, and position requirements and job descriptions with the redaction of any confidential personal information, as well as personal information such as social security numbers, date of birth, and university ID number. University will include in the policy an agreement to release the information that is required to be released pursuant to 22.7 sub 11 if the individual becomes an employee. The university will include in the policy that the final signed offer letter will be released if the individual is hired. The policy will be provided to the IPIB for approval within 45 days of the approval of the informal resolution. And finally, the university will release the records and information necessary to properly respond to the record request from Ms. Miller. I'm not entirely certain, but I think Margaret had made a comment that some, if not all, records were released to Ms. Miller. That might have just been an offhand comment. I wouldn't put too much weight on it. She did receive copies of the records she requested. There it is.
Okay. And she was happy, obviously, with the informal resolution.
Yes, and now I see I should have read this report closely. All the terms have already been completed, so she's not only requesting approval of the informal resolution, but also dismissal of the complaint.
Okay. I must say this is a happier resolution than I thought we were going to get when we first heard from the university. I'm pleased it wound up this way. We have a motion to approve the informal resolution and dismiss the underlying complaint.
Before that, did Ms. Miller sustain any personal damage from the delay? Do you know?
In terms of...
Well, she requested the documents.
And she received them, yeah.
Hinder her,
I'm not aware.
damage or no?
Margaret had virtually all communication with the parties. My guess would be that if there was any kind of damage, it would be in the form of, since she's a reporter for the Gazette, maybe not being able to publish some things as timely as she would have liked to have. That would be the most that I could think of off the top of my head.
And it was the kind of information that had been disclosed routinely, so she it was good that she brought the complaint to our attention. Got them back on track.
Okay.
Do we have a motion? Are people still reviewing it?
Also moved.
Second, Barry.
Joan, I would.
Okay, it was moved by Susan, seconded by Barry. And we have, what the motion is then is a motion to approve the informal resolution and dismiss the underlying complaint. All in favor signify by saying aye.
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 Aye. Aye.
Any opposed? Okay. The informal resolution's approved. The underlying complaint is dismissed. We have the next is the Monroe, Iowa 1867 complainant. Must be some kind of a committee.
Actually, this complaint came in essentially anonymous except for the email address. And so,
so that's why you captured
the reference to that.
Okay.
On December 14th, this complaint was filed number 21 FC 120. It was sent to an email address. The complaint alleged violation of Iowa Code 21 by the city of Monroe. The complainant alleged that on Monday, the December 13th, 2020, city council meeting was changed to a virtual meeting without public notice. It further stated that no information about the change was on the website, nor any link provided to allow the public to attend. On December 15th, the city responded to the complaint and stated on Thursday of last week, per mayor's request, due to COVID exposure in our city office, this was made by the clerk, I was asked to do a virtual meeting for the protection of our citizens on December 13th. I then changed the agenda, which was posted in 3 different locations and put on the city Facebook page. I also notified the Prairie City Monroe Explorer and Newton Daily News on Friday by email with the updated agenda and council packet. I contacted people whom were on the agenda to speak and our regular monthly meeting attendees by phone. The agenda had the Zoom information on it and was posted on our bulletin, on our board outside the city hall, all which were in the 24-hour notice guidelines. A copy of the notice and agenda for the December 13th meeting were reviewed and received. The notice met the requirements for an electronic meeting pursuant to Iowa Code Chapter 21.8 and included the login information for Zoom attendance. Iowa Code Section 21.4 requires notice of a meeting be posted no less than 24 hours prior to a meeting. This section requires posting at the principal office of the body holding the meeting. It is not required that the city post notice on social media or a website. So Section 23.8 requires compliance with the ISBA's jurisdiction, legally sufficient, and have merit. This complaint does not meet those requirements. Therefore, dismissal order.
When you get just an email address, do you respond to it?
Absolutely. We treat those complaints exactly like the others because we do have a way to communicate with them with an email address. Okay. It is the complaints that we get in that are blank that we have no way to deal with. And so we put a catchka, is that what it's called, on our forms that is the one required field that is an email address. And we even tell people if want to be anonymous, if there's a way that they can create an anonymous type email address, at least we can communicate with them. So if it doesn't want to be identifiable, like first name, last name at Gmail, if there's another way to do that. So we treat this complaint the exact same. They get each side, every response that comes gets to each party, and so that they were given an opportunity to respond.
Okay. And I'm guessing they're not on the phone.
They may be. I mean,
well, let's look it through.
Is it allowable then they could just respond under that email?
Sure. Sure, because if it came to the point where we accepted this complaint and wanted to work out an informal arrangement, informal resolution, we'd still have an ability to communicate with them. And that's sort of the baseline that we think is important in the office with complaints, is if we have a way to communicate. If it was just a phone number, I think, we could do that too. Because we at least could say, we need to be able to send you something or share this information with you. Otherwise, we don't have a way, when we're just gathering information at the time of a complaint, we're not investigating the complaint. We have to have a way that we can ask each side for the information and allow them to respond to the information for the purpose of bringing it here to you to decide to accept or dismiss.
I think we dealt with this at the very beginning, and we didn't want anonymous. Do you remember that?
That's right.
We didn't want anonymous complaints. And because, you know, people can stir up trouble for whenever they want to stir up trouble. There's no,
But if I lived in a town of 200 people and I thought my government, my city was doing something wrong, I probably wouldn't want to disclose my name. And I think you have an email address and, you know, that can, you can
well,
get.
but I think
you
in a town of 200, you'd know anybody that's in that position, but I grew up in a small town at the time, but.
And the most common
I don't
comment.
know, I thought we'd always, we'd kind of discussed this before.
Yeah.
I think when we started, I don't know if it's in the rules or where, but I thought a person had to identify themselves.
Well, we talked at the Rules Committee, but I don't think we've done anything about it yet, that as far as I can tell, all you could do is promise them some confidentiality under 22-718. But if it came to a hearing, I don't think you can keep them anonymous.
Right, and that was where that discussion in the Rules Committee left off at, because we were unsure if we needed a rule that would describe the process for being anonymous if you had to request before filing a complaint. But then, since we were able to confirm with OCIO, who is the custodian of all the state of Iowa emails, that, you know, if someone called Brett afterwards after filing a complaint saying, hey, I want this to be confidential, then we don't have to worry about those records getting out. So there is a way to do it. It's just not as overly formal.
And really, you have an email that lets you articulate the complaint and describe it. I mean, you could also go to Spencer or whatever, I'm thinking about my husband in Webb, and get a P.O. box. You know, you could get 123 Spencer, Iowa, or you could even get a P.O. box probably in D.C.
I don't think that's a good idea.
So, I mean, you could, you know, you're never
I know
going
you
to,
could
there's
go-
lots of ways to make yourself more
Right.
anonymous. The real important question, I think, for us is that there's some way to get back to someone so we can articulate and completely understand the issues.
Right, and I think what's always been suggested, because to me it makes the most sense by far, is to just do it through email. It'll take a minute to set up a Gmail account that can have any name, but, you know, as far as phone or P.O. box, I mean, they could do that too, but that'd be a lot of hassle for an IPIB complaint if you ask me.
Yeah. We do put on our website and on the top of our forms that if you want to remain anonymous, please contact the executive director and discuss that matter.
Well,
But I think what we find most, the calls I get most often when somebody wants, they said, well, I can be anonymous, it's because they're a small town, they don't want to be bullied by their government. There is a true friction between what they're doing and the government, and they don't want to, they want it to be known that they don't think their government is doing something right, but they don't want the ramifications of what might happen to their street not getting plowed in front of them or something.
Well, I think Keith raises a good policy question, whether the board wants to just not accept anonymous complaints. And then you'd offer them 22-718 protection as an alternative. We won't tell the world who you are, but we would need to know.
I guess my question is, what's anonymous? I mean, you could, I mean, what's anonymous? If you have a P.O. box and you have ABC 123 as your email address,
well, I just want to point out, when we started, that was not.
They didn't want to take
There
it.
was no such thing as an anonymous complaint, and that it was discussed.
Well, and I know Margaret would point to the example of, you'll recall, several times we've gotten complaints from Iowa Live. You know, it's an entity. We don't know who they are or who the personalities are of it, but we can communicate with them and get back and forth response. So I remember the day we had the Rules Committee and we kind of wrestled with this of how do we make this available to the public, help resolve their issues, but at the same time keep it safe for them.
Well, I guess to Keith's point, he doesn't think you ought to offer them that
Yeah.
if you're going to complain about your neighbor, you need to say who you are. And the board could choose to do that and just not take anonymous complaints. Then offer them instead confidentiality under 22-718.
Yeah, my memory of the beginning was somebody would call in and they'd want to be anonymous, and I would usually, I think it was common to be from a smaller community, and you could talk to them, and a lot of times they'd have some idea about the mayor doing something, and you said, well, I'll call the mayor and talk to him. I'd don't have your name, and I don't really know whether,
Yeah.
you know, so if the mayor tells me something, I know his name, and he or she is gonna be the one I'm gonna rely on.
You know, I think if you promise people confidentiality, I mean, that's kind of a hard thing to understand. I think
Yeah.
my concern is that we not quell complaints or quell the ability of people to complain.
Well, and then when you do that, my perspective was that if I do that, I might be exposing somebody to danger.
Mm-hmm, yes.
And so I just thought it was, and Bill Monroe was into that too, that you create a situation that could lead to unanticipated consequences.
Well, as a policy question, it goes either way. If you give people anonymity, you can get people who are just troublemakers and are stirring the pot and don't want a name associated with it because there's nothing to it. But I guess that's a policy issue the
Yeah, well,
board
if
can
our
resolve.
rules allow for this now, why, I mean, obviously we can do it. Because we've adopted a rule apparently that.
There's nothing that precludes.
Yeah, we don't have a rule saying that you can't have it, we just don't have a rule saying you can. And we've also had situations where we've had complainants who will use more than one name. I don't know if it's because they get married or divorced or what, and then that might bring up the issue of how do we actually know that, you know, Ms. Weinbrenner is Ms. Weinbrenner.
Well, we seem to know that this should be dismissed. Whoever's behind that email. We can take this up further if people want to, whether you want to bar anonymous complaints, but for today, we can have a motion to approve the dismissal order.
Yeah, we might want to look at whatever the rule is.
Yep, I'll add it.
Make it available, I don't know that anybody else could deal the way I do, but it's a concern.
Are we ready for motion?
Yep.
I'll move
Approval?
approval of the dismissal order, yes.
I second.
Moved by Susan, seconded by Rick. All in favor of approving the dismissal order signify by saying aye.
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 Any opposed? It's approved. That brings us to Pam Weinbrenner. I think we have another motion to continue.
Yeah, this is a motion to continue. Originally, the due date was going to be January 17th. They requested an extension to February 14th, I believe. Yes, February 14th. And just for some background on that, they did have training. They had it on December 21st, but it was not in an open meeting as the terms require.
Oh, there's some irony.
Yeah, so they are working to reschedule that with the league, and there's no issue of not being cooperative. I think it was just an oversight, and I was actually informed by Ms. Weinbrenner. She wanted to attend the meeting, and then she heard from someone, I don't know how, that it's going on right now, so she emailed me. I emailed the city attorney. He didn't get back to me, unfortunately, until after the fact, and realized, oh, duh, could have had a V8, and then said, of course, we'll do what we need to do to comply with the terms. So that's the reason for the motion to continue.
So they really, really need the training.
I'm not sure if they have new council members either, but it'll also be helpful for them if they do have them.
Well, I'm glad they're willing to do it over in an open session. Motion on the motion to continue.
I'll move it.
Okay. Moved by EJ, seconded by Keith. All in favor of continuing the Weinbrenner matter, signify by saying aye.
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 Aye. Aye.
Any opposed? Okay, the motion to continue is granted. We have a matter withdrawn by email.
Yep.
Pending matters are listed for your information. I have a question. Clark, what's the status of Clark Kaufman and the workforce development issue?
They're still working on, so the terms of that informal resolution is mostly for workforce development to develop a policy, because they didn't have really anything along the lines of responding to public records requests. If you remember a complaint we had against the Department of Public Health, it was very similar to that. We actually are using the policy that we worked with on Department of Public Health as a basis for workforce development, and they just needed an extension because they were slammed with a lot of end-of-year unemployment stuff and the changes that the legislature made last fall as well. So they're working on it.
And these are the people that were letting Verizon's policy control.
Yes, and we made
Okay.
clear that that is not.
That won't do it.
Yeah.
So we'll expect it at the next meeting.
I am not certain. I don't know what's happened in the past few weeks since I left. I know that last I knew, my hope was February, and I know Margaret and I had also talked about, if it's not February, then it basically needs to be February, because at this point we've given them plenty of time.
Right.
So I would hope it is, and I think that's Margaret's hope as well.
Thank you.
Can we let them know that?
I'll make sure that she knows, and she can check in with David over there.
Committee reports.
Nothing on communications. I know Margaret is tracking the legislation.
Yeah.
And I'd help with that, but she knew she was going to be on the phone today and took that file with her. So,
And I actually,
so I don't have those notes.
I am still subscribed to all the IPIB legislation, so I've been getting updates whether I want them or not. And I don't know if the only bill is the 60 to 90 day change, but I do know that got a subcommittee, I think, for sometime next week.
Yeah.
I think there were, like 3 bills or?
Yeah.
And they were the same bills we offered in past session.
Does that bring us to the legislative committee?
Yeah, that's what I just reported on. Sorry, I jumped here. Go ahead.
Which is exciting.
And Rules doesn't have a report, but we should soon. We've got several things to take up next time.
Yeah, I'll pass all this along to Margaret.
Office status reports.
Contacts, I just point out, we just finished a calendar year, and we ended the year with 700, which is down about 43 from the previous year. So I would say that we had a status quo year in terms of contacts. And number of complaints is actually what I kind of judge. And we ended with 124 for the year, and the year before we had 133. So I'm sure those will go up now that we have new leadership at the ethics board.
Oh, you better bet on it.
And the website report is as normal. I pulled the numbers, and it looks like, year over year, our website continues to gain usage as people find it.
Finances?
Everything's fine in terms of where we're at current year. On the appropriations side of things, our governor came out with a recommendation at a status quo as last year, as we expected. I wasn't sure. I had hoped that we could incorporate a little extra money in anticipation in fiscal year 23, the possible retirement of Margaret, and any extra costs we might have related to that. But right now we're at a status quo budget. House Appropriation Committee met for the first time this week. We haven't been scheduled for an appointment to come in and say hello. We did meet with the chair of the House side of the Appropriation Committee 2 weeks ago. And then some other agencies who have new directors have already got their appointments scheduled.
Yeah.
So
I'm up next Wednesday, so tune in. It'll be fun.
We'll leave them nameless, but we anticipate within 2 weeks we'll go in and share with the committee what we're doing and why we deserve to remain a state agency at same funding.
When you say status quo budget, do they plug in like raises, salary raises? I mean, does that reflect no salary raise or that?
Yeah.
Is it just automatically increased or whatever?
It's what we have this year.
Okay.
And the whole salary thing,
I'll bet that's in some other bill or something.
it comes through another bill, and how, you know, how good a job you do, and being a small agency, it's a little frustrating. We don't have the flexibility within our salary part of our budget that some agencies do because of attrition. If we have 3 people stay all year long, there isn't any gap for extra. But
You're welcome for the gap.
but thank you for a little bit of the gap. But and so I guess, could I talk a little bit about transition?
Go ahead.
So Zach left the office the beginning of January. We have posted the job, and we have the end date the 28th. We've been getting some applications in. Look like some good applicants. We plan to exceed what Zach's level was, so that's good. Our intern Logan, we have brought him on as a paid intern this semester. He was willing to earn a little extra money on the side, and so he's helping us review cases,
He
complaints.
did quite a good job on this
Yeah.
issue.
On the
Yeah.
amendment.
He wrote a memo and, but then he dug, because I'm not easy to please, I guess. But he kept digging and he really did answer my question, which I really appreciated. But he wrote a really good memo also.
Yeah, yeah, we're really happy with the semesters Logan gave us, and
What year is he in?
He's in his last year.
he's, yeah, little tricky on the timing. He's got his semester to finish, but I don't know how soon we need to get somebody in. But that's okay. If Logan's interested in our position, he can submit his application, and we'll take a look at that.
I think I saw the posting, but what is the salary range that we're offering?
It starts at, I think, 55 now, after a couple years of increases. The range is extremely
Yeah.
misleading. It says the range is 55 to like 102,
Yeah, it's like
which,
that, yeah.
yeah, which you're not going to
Good.
get. You're not going to get that. Otherwise, I'd still
But
be.
isn't it kind of given it's going to be 55?
Yeah, because unless you're coming from another state agency where DAS has a rule that you have to get a 5% bump up, I was forced to start at the minimum. I'm sure most people would have to start at the minimum, so.
Okay.
Yeah, those ranges apply to everybody
Okay.
across state government, and they're a little tough on the smaller agencies. So if you haven't been able to tell, I'm a little biased. It's a little tricky working with our budget when we don't have a lot of flexibility.
Can you let us know, board members, when we appear before the budget
Oh, I'd be happy to.
presentation? I
I'd be-
came last year to that,
Yep.
and I enjoyed it. I'd like to do it
Be
again.
happy to. We can do that easy.
And or who the committee is, just in case it's someone from Northwest Iowa that I know.
This is
Well, it would be, it's the administrative
Okay.
subcommittee of the full appropriations committee. So you can just,
Yeah, we went, I think Keith and I went once before, not last year, the year before, I think. I can't remember, it was before you got here, I think.
yeah,
But
that'd be
anyway,
fun.
so I'd be willing to go.
You can come, Rick, as long as you don't interrupt me.
Oh, geez. That'll be hard.
A non-agenda item, but my term is up in April, and I've told the governor that I did not want to
Oh,
be reappointed. So if you've got some people in mind that might,
Goodness, I'm disappointed.
Well, and I did, mine is up also, and I did say, I've kind of been in this from the beginning, and I don't think it's quite as, not as far along as I thought we would be in 8 years, and so however many years it's been, so I'd be happy to serve another term.
Good.
I don't know what the governor wants to do. I don't have any idea what they want to do, so I might be adios too in a couple of months.
Well, it would be good if one of you continued.
I'm up, and I asked to be reappointed. If, with Keith leaving, that'll just leave one media member.
That's right, the media.
I would be concerned about losing that.
and that's one why I wanted to bring it up, we can get it out now, so that the INA or other people in there, might be able to get some people up to the governor's office.
And then, EJ, are you a 22 also?
Yeah.
Are
So
you?
we have 5 people going out.
Oh, wow. That's a
6
lot.
counting Stan.
With 6
Are you going
counting
to stay, EJ?
Yeah, I told him.
This is Monica. I am too, but I did tell them that I would like to be reappointed.
So did I.
Did you? Good.
Susan, I'm curious if I can ask. You said we're not as far along as you'd like us to be.
Oh,
Could you help, if we want to get there, maybe we should share that.
I guess, okay. My vision for the agency, and I'm not even sure that it's doable, was that by this point in time, there would be a lot more materials for public officials, just like, we've talked about, I don't know, best practices. I just talked about the library issue. I had been my goal, when I got on, I've been involved in public records for a long time, and I always found it hard to deal with. And I know I've worked with a lot of small towns over the years, and I know, how much help they can be. And I bet a lot of these don't even belong to the League of Cities or the Association of Counties. So I had hoped we would have a lot more easy materials and a lot more, I guess, history that could be used by small towns to know what to do. I'm not, you're in the Association of Counties, others are in the League of Cities, maybe those materials are out there. But, people don't even know how to close meetings, they don't know when meetings are supposed to be closed. We've got a body of complaints, but I wish we had more practical materials that could be used by cities with part-time clerks.
It seems to me, and I understand what you're saying, but it seems to me that we reach out about as much as we can. So I guess the next question is, how do we get where you'd like to go? And it seems to me that that's, to a large extent, going to deal with budget and personnel.
Yeah, we have FAQs, but they're pretty much all the FAQs from the association. They're not our own FAQs. I had always hoped there would be practical materials that could be used. Like, the ethics board is an illustration. You don't have to know the rules to figure out how to make ethics file.
Well, the reason I ask is there's something we should be doing, if you think it's something we should be doing going forward, then we as a board should consider that.
I would like to see practical materials that could easily be used by local governments on some of our issues. And even when we do resolve a complaint, issue something that would be easy for the public to understand and see and use that to govern their behavior in the future.
Well, when we started, Bill Monroe was chair, and then we went around, and it was like a 6-year war over there with various public body groups, and so we got a hold of the representatives, and we offered to volunteer to go out to all their annual meetings and make a presentation. I think they're still doing some of that, right?
A little bit, when we're invited, yeah.
Yeah, and so we went around, well, we didn't have any, I don't think we even had a budget yet, but the budget didn't go into effect until after we got started, but, so that was well received, and we should have documents that we
let me use one illustration. I fought with the city of Sheldon for about 10 years. They wanted to form a municipal utility, and they didn't really want to tell Iowa Public Service Company what they were doing. So for like 4 years, they had meetings. They would bring their lawyer in, and they would say, well, we're talking about this, it's pending litigation, or it's imminent. And I would have liked back then, this was in the 80s, to have had something where I could show the people, the city of Sheldon, are you following this? That's just one illustration of the kind of materials that I had hoped, that I thought would be helpful for our agency to have.
Yeah, of course, if somebody wants to get around the rule, they're going to get around it, but.
Yeah.
No, I understand what
But
you're
it would
saying.
be hard, it would be a lot harder for that city
Right.
attorney if there was something from the IPIB that explicated that.
Well, my presentation, I would say probably the worst thing you can do is as a council member or whatever, try to resolve something very controversial.
Her annual report
You're going to
is on
just cause
this
a
agenda.
more headache for yourself. And if you let the public see the struggle you go through to get to the end point, probably were gonna respect you for what you did on your job, instead of finding out about it, reading, in the minutes. So, we really went around and Bill and I attended a lot of meetings and did a lot of research. And we did prepare documents, and what, they probably got improved on over the years.
I'd also have to say that one of my motivations was the Klein case. When I re-upped, the Klein case wasn't out, and I thought, I'd like to be here when the Klein case is finally resolved.
We may never all be here when this is resolved.
Then you have to re-up again.
So that was part of it.
You might explain that to the governor when she's considering to reappoint you.
Right before the rat shoot.
Why don't we finish out the agenda? We need to approve the annual report. Margaret's, it was at the back of your agenda materials.
Yeah, hopefully you read through, if you saw anything that needed to be changed, I guess let me know, but I think in the past, we have actually approved the annual report, and then we're required, we'll submit it to the legislature and the governor as required by code. What?
You said you had to make a change?
No, I asked if you thought that there were anything that was inaccurate, whether it's about your bio or...
Julie's name is spelled wrong at the end. It needs an extra F.
What?
Just one F. I thought it was 2 T's and 2 F's, right?
It is.
Okay. Yeah.
Well, let's get that corrected.
The next to last word is hold up.
Yeah. Well, we'll take that as a
I didn't even notice.
friendly change. I'll just say as a personal note, what I really enjoy when I put these together is trying to capture some of those comments that we've gotten back from people, and even some of the summary of the variety of cases that typically come in. I think that really makes for a good read, especially for the legislature, to see the scope of what we do. So,
I thought it was very good. It's thorough.
but it's very similar to every other year, so
Yeah.
I'm
Well,
not
EJ
going to
just-
take credit for all of it, but I do enjoy putting that together. It's kind of fun summarizing.
And EJ just had an idea. I don't know if it needs to be clearly noted that I'm no longer on staff.
Yeah, but
You know,
not in this annual.
I
Or is it just 2021?
kind of argued with
Okay.
Margaret, who's a journalist, about that. This is a report about the last
Yeah,
year,
yeah.
not about
That's
the
fair.
future
It's an
year.
annual
So I
report.
think-
And so,
It's history.
Well, with the correction of my name, can we have a motion on approving the annual report?
Second?
Moved by Susan, seconded by EJ. Approval of the annual report. All in favor?
Aye.
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 Any opposed? And now if we can have a motion to adjourn, we can go back out in the bitter cold.
I'll move.
I have a question.
Okay, moved by EJ, seconded by Rick.
You were,
All in favor of adjourning?
Aye.
Aye.
talking about.
Aye.
Aye.
Thanks, everybody. We'll see you next month.
For the first period.